It is Tuesday, August 24th, 2021. I am Ashley Pollard here for a late night edition of Tuesday Talk, where we review common real estate and mortgage related terms. I know it's late, so you can either watch this as you're winding down for the day like me, or watch tomorrow when you have time. But I did want to make sure we got in today's term, no excuses. So today's term is deed. And a deed is a written document that is going to convey an owner's title or interest in a property. It does have to be signed by the owner, and it doesn't have to be dated. That's not really important. So there's 4 types of deeds, and the first one provides the greatest amount of protection because it's going to extend back to all previous owners. It's called a warranty deed or a full covenant and warranty deed. And it's called that because it comes with certain warranties and covenants. What are these things? It's going to convey that or state that the owner has the right to convey the title to the property. It's also going to state that the title is free from liens, claims, charges that might exist. They don't exist. It's going to state that the new owner is free from legal recourse by any third party that might bring about action in the future. It's going to also state that the owner will do any and everything necessary to make sure that the title is conveyed and it's clear, and that the owner will compensate if the title fails or if there are any defects found in the future. So it provides a very, very extensive level of protection. A good situation to use this in is if you have been the only owner of that property, you bought it when it was new construction, or you are older in age, your entire family has always lived in this house, so you know the history of it. You owned it before recording was even a thing. Those are situations where you can confidently use a warranty deed because you were the primary and sole owner. So that's that one. Provides the greatest protection. The second deed is a special warranty deed. It has a formal name that's kind of complicated. So special warranty deed is also a term that's used. And this is actually the primary deed that's used in the state of New Jersey. And it's going to cover me as the owner. It's not going to extend back to all the previous owners of the property, but it will state that I, as the current owner, have not done anything to bring about claims or charges on the property during my ownership. And that, again, that's the main one that we use in New Jersey. And I am warranting about my ownership. I'm not warranting about anybody else's ownership. And yeah, as the buyer, that's providing less protection than the warranty deed. But think about you as a seller. Do you want to be responsible for who sold the property to you, or who sold the property to the person who sold the property to you? If things happen in the future, you don't. So be realistic. Think about both sides when you think about how to go about some situations. Don't think only one-sided. It makes sense. Some of these rules are in place so that everyone's protected. And honestly, if you hire a really good team who's going to do the due diligence, hire a great title company, hire a great attorney, they're going to make sure that these things are done for you. So bargain and sale deed is the third type of deed. It is going to state that I have title to the property, but I cannot guarantee anything about anything. And these types of deeds are used in foreclosures and tax sales. So think about the bank, right? In a foreclosure, yeah, I have the title. I'm the bank. I have the title, but I don't know what the previous owner was doing. I'm not gonna, say yes, I'm warranting, and then later on we find out there's a $75,000 lien on the house. No. So again, that comes back to you doing your due diligence, hiring a really great team who's going to search the public records for you and find out whatever information you need to find out about the property that you're interested in. Last deed, the fourth deed, is a quitclaim deed. It provides the least amount of protection out of all the deeds because it is just saying, if I own this property, I'm conveying title. That's if I own it. Now, I might own it. The title might be good. It might be clear. But it's if. I'm not guaranteeing anything. And you're thinking maybe, why would I ever use this? Well, this would be a good deed to use for a simple family transfer. Maybe a parent to a child. this also would be good to use in a divorce situation where both parties have been living in the house and they know the history, they know the financial history of the house, and one of the parties is moving out and they're going to transfer ownership to the person staying. So those are situations where you could use a quitclaim deed because it's immediate. It's not like a stranger that you're doing the sale with. Some other things I want you to know about deeds are that minors cannot be grantors or people giving property. Only 18 years of age or older adults can be grantors. And if there is a contract or a deed or anything signed by a minor, that is always voidable in court. They're not going to recognize that in court. Same thing applies for incompetent people. A court is not going to recognize anything signed by them. So please know that. You on the flip side, though, you can receive property as a child. You can receive ownership. You just can't grant it. To be valid, a deed has to state some sort of consideration. So the consideration could be $400,000. The consideration could be love and affection. It could be $1, which you'll see for like simple family transfers. It does have to state some sort of consideration to be valid. And there's also some other descriptions and clauses that have to be included in deeds, but there's things like you can give ownership of the property but still leave some rights to you. So example of that would be a farm, right? You have a farmhouse, you give the deed to the house to your nephew, but then you still reserve the right to use the land in the back to cultivate your crops or something like that. You can also give ownership to a property and limit the uses of that property. The new owner can only use the property for XYZ. They can't use the property for this. These are all things that you can talk to your real estate attorney about. And if you have any other questions or want some other tips, just call me, your one-stop shop realtor. And if I can't assist you, I know the people who can. I appreciate you for tuning in today. Know, as always, that I'm giving you straight facts, actual factuals from the real estate book itself. And like, this is not a game. Look at the pages I've highlighted. I take notes. I'm giving you guys facts. And I wanted to make sure, even though it's late, you guys got the facts today. So thanks for tuning in. I will see you next week. Have an awesome week. Have an awesome rest of your day, whatever time you're watching this. And give the world the best you, as always. Have a great night.